Special counsel Jack Smith after a judge temporarily blocked the release of his final report on investigations into President-elect Donald Trump. It's part of a lawsuit by Trump's former co-defendants. Smith says his team is finalizing a 2-volume report on the now defunct investigations. Trump's lawyers are asking the Attorney General not to release it at all.
Okay, so imagine you're on Trump's legal team. You think you've won. You got a Trump-appointed judge to block Jack Smith's report from being released. You convinced Judge Cannon to issue an injunction stopping publication of Smith's findings about January 6th and the fake elector scheme. You think the damning evidence is going to stay buried. Think you've successfully prevented the American people from seeing what Smith found, and you're celebrating, getting ready for the weekend, thinking you've bought Trump some breathing room. And then late Friday night, you get an alert. Jack Smith just filed an emergency motion, filed it with the 11th Circuit Court of Appeals, and he's asking them to immediately lift the injunction, to allow the report to be released, to override Judge Cannon's order. And you realize the fight isn't over. Realize Smith isn't giving up. Realize you're about to spend your weekend scrambling to respond, drafting emergency briefs, calling other lawyers, trying to figure out how to keep this report buried. Because if it gets released, if the American people see what Smith found, that's devastating for Trump. That's evidence of crimes. That's documentation of election subversion. That's material that could influence ongoing investigations and future prosecutions. So you can't let it out. Have to fight with everything you've got. But Smith just made that fight much harder. But before we go any further, real quick, let's be honest, you can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
Judge Cannon is not actually doing much other than saying nobody's sharing this report for at least 3 days outside of the Justice Department. So we were awaiting the release of Jack Smith's final report, the summation of all of his work, his charging decisions in both the classified documents case before Judge Cannon and the January 6th case, which is against Trump in Washington, D.C., or was. It's been dismissed now. The Justice Department said they could release it publicly as early as Friday at the Attorney General's decision if he wants to do that. And so Trump's team, the co-defendants in the classified documents case, he has 2 of them who work for him, also accused of obstruction of justice. They also are facing the dismissal of this case, but ongoing appeals. They are going to court and saying, we don't want any of this to become public because it could hurt us. And so Judge Cannon said, yeah, let's look at the appeals court here. You've asked them as well to block the release of this. I'm going to say now, today, no one who gets this report in the Department of Justice, who has it with Special Counsel Smith's office, their officers, agents, employees, no one can share it outside of the Justice Department.
The motion was filed late on November 14th, late Friday night, and the timing is strategic because filing late Friday means Trump's team has less time to respond, means they have to work through the weekend, means they can't use normal court hours to coordinate, have to scramble. And Smith knows this, knows that emergency motions filed Friday nights create pressure, create chaos, force rush responses that might not be as strong as carefully prepared briefs. So the timing itself is tactical. Is Smith using every advantage, using every tool available to get this report released because he believes the public needs to see it, needs to understand what Trump did, needs to have access to evidence that's been compiled through years of investigation. Smith's legal argument is straightforward. He says Judge Cannon lacks authority to block the report, that her injunction is improper, that the legal basis for stopping publication doesn't exist, and he's asking the 11th Circuit to intervene to say Cannon got it wrong, to lift the injunction and allow release. And Smith's motion is detailed, is comprehensive, makes legal arguments about why publication should proceed, about why the public interest demands transparency, about why Trump's claims of unfair damage don't justify suppressing evidence. And those arguments are strong, are exactly what you'd expect from an experienced prosecutor who knows how to win in appellate courts, who understands what arguments will persuade judges, who knows how to frame issues in ways that make his position seem obviously correct. Trump's legal team is scrambling. They filed their own emergency motion, asking the court to keep the injunction in place, to maintain the block on publication, to prevent the report from being released. And they're arguing that releasing the report would unfairly damage Trump, would prejudice potential future proceedings, would violate Trump's rights. But those arguments are defensive, are reactive, are Trump's team trying to hold on to a temporary victory rather than making affirmative case for why reports should never be released. And defensive arguments often lose, often sound like you're trying to hide something, often make judges wonder what's in the report that you're so desperate to suppress. The appeals court has already partially ruled, denied Trump's emergency request to stop publication of the election interference findings, said that part of the report can be released, but Cannon's injunction on other findings remains in effect, so it's a split decision. Part of the report can come out, part remains blocked, and that creates this situation where some damaging information about Trump is going to be public, while other damaging information remains hidden, and that partial release might actually be worse for Trump than full release would be, because partial release lets people speculate about what's being hidden, lets them imagine it's even worse than it probably is, lets Democrats and media talk about Trump hiding evidence about what he doesn't want people to see, and all that speculation and discussion keeps the story alive, keeps it in the news, keeps damaging Trump. The substance of what's in the report is why this matters so much. Smith spent years investigating Trump's efforts to overturn the 2020 election, interviewed hundreds of witnesses, collected thousands of documents, built comprehensive cases about January 6, about the fake elector scheme, about pressure campaigns on state officials, about all of Trump's attempts to stay in power despite losing, and Smith documented all of that, put it in detailed reports, made findings about Trump's conduct, drew conclusions about whether crimes were committed, and those findings and conclusions, they're apparently devastating, apparently show Trump engaged in criminal conduct, apparently provide evidence that would support prosecutions, and Trump desperately wants that information kept secret, wants the American people not to see it, wants to prevent the evidence from influencing public opinion or providing ammunition to other prosecutors. Smith is arguing the public has extraordinary interest in seeing this report, that understanding what a former president did to try to overturn an election is crucial for democracy, that transparency about government misconduct is essential, that the American people have a right to know what their elected officials did, and those arguments are powerful, are exactly the kind of thing appellate judges respond to, because judges generally favor transparency, generally think government information should be public unless there's a really good reason to keep it secret. In Trump's arguments about unfair damage, they're not strong enough reasons. Don't justify keeping evidence of potential crimes hidden. Don't overcome the public's right to know what their president did. The judicial independence angle is significant because this is Smith, a special counsel, fighting against a Trump-appointed judge's ruling. Is Smith saying Judge Cannon got it wrong, that her injunction was improper, and asking a higher court to reverse her? And that dynamic, that willingness to challenge a judge's ruling, that shows Smith is serious, is willing to fight, is going to use every legal tool available, isn't going to just accept defeat and walk away. And that tenacity, that determination, is creating problems for Trump because Trump's strategy has been delay, has been using friendly judges to slow things down. But if appellate courts keep reversing those judges, if higher courts keep saying Trump's legal arguments don't work, then delay doesn't work anymore. Then Trump has to actually face accountability. So buckle up, because we're about to break down exactly what Smith is arguing and why this motion has Trump's legal team absolutely panicking. All right, let's dig into what Jack Smith's emergency motion actually says, because the legal arguments matter, the strategy matters, and understanding why Smith thinks he can win this fight, that's essential for predicting what happens next. So we start with Judge Cannon's injunction. Cannon is the Trump-appointed judge who's presided over some of Trump's cases, and she's been criticized for rulings that seem to favor Trump, that create delay, that accept legal arguments most judges would reject. And in this case, she issued an injunction blocking release of Smith's report, said that releasing it would cause irreparable harm, would prejudice Trump's rights, would be improper while related cases are still pending. And Trump's team celebrated, thought they won, but the report was going to stay buried. But Smith is arguing Cannon's injunction is legally wrong, that she didn't have authority to issue it, that the legal standards for injunctions weren't met, that her reasoning doesn't hold up. Smith's motion makes several key arguments. First, he argues that special counsel reports are supposed to be made public, that the regulations governing special counsels require transparency, require that findings be shared with the public, and that Cannon's injunction violates those regulations, interferes with the special counsel's mandate, prevents Smith from fulfilling his obligations, and that interference, that blocking of a special counsel report, that's a serious problem. Is a judge overstepping her authority? Is judicial interference with prosecutorial function? And appellate courts generally don't like that, generally think lower court judges should defer to prosecutors on how to conduct investigations and present findings. So Smith's argument that Cannon exceeded her authority, that's likely to resonate with the 11th Circuit. Second, Smith argues the public interest strongly favors release, that Americans have a right to know what their president did, have a right to understand whether Trump committed crimes in attempting to overturn an election, have a right to see evidence that's been gathered at taxpayer expense through years of investigation, and that public right to know, that transparency interest, It outweighs Trump's claims of potential harm, because Trump's harm is speculative, is about possible future proceedings that might be affected, but the public's interest is concrete, is about understanding whether their democracy was attacked from within, is about knowing whether their president betrayed his oath. And when you balance speculative harm against concrete public interest usually wins. Usually courts say transparency is more important than protecting powerful people from embarrassment. Third, Smith argues that Trump's claims of unfair damage don't justify suppression, that Trump is a public figure, is someone who chose to run for president, chose to engage in conduct that became subject to investigation, and public figures don't get to suppress evidence just because it's damaging, don't get to claim that releasing truthful information about their conduct is unfair. The standard is much higher, requires showing that release will violate specific legal rights, will prejudice specific proceedings in ways that can't be remedied. And Trump hasn't met that standard, hasn't shown concrete prejudice that justifies suppressing an entire report, has just made general arguments about damage to reputation and potential future difficulties. And those arguments aren't strong enough to overcome the presumption of transparency. The co-defendant angle is interesting. Carlos de Oliveira is the Mar-a-Lago property manager who was charged alongside Trump in some cases. And Trump's team is arguing that releasing the report would harm de Oliveira too, would prejudice his rights, would make it harder for him to get a fair trial if cases are ever revived. But Smith argues that's not a valid reason to suppress the report, that de Oliveira's potential prejudice is speculative, that the report's findings are based on evidence that would be public anyway in any trial, that suppressing the entire report to protect one defendant's potential future interests doesn't make sense, and courts generally agree, generally say that transparency concerns outweigh speculative claims about future prejudice to defendants. The timing of Smith's filing is significant. Late Friday night creates pressure, but it also suggests urgency. Suggests Smith thinks getting this report out quickly matters, maybe because Smith is worried about further legal maneuvers, worried that Trump's team will find more ways to delay if given time, worried that the window for release might close if he doesn't push aggressively now, or maybe because Smith thinks the public needs this information now, needs to see it before more time passes, before memories fade, before people move on to other issues. Whatever the reason, the urgency suggests Smith thinks delay serves Trump and quick release serves justice and transparency. The 11th Circuit's partial ruling is revealing. They denied Trump's emergency motion to block the election interference portions of the report, said those findings can be released, but they left Cannon's injunction on other portions in place pending further review, so it's a mixed result. Smith got partial victory, gets to release some findings, but not everything. And that partial release is both good and bad for Trump. Good because some damaging material stays hidden, bad because partial release draws more attention, makes people focus on what's being released, makes media coverage more intense, makes the contrast between what's public and what's hidden more obvious, and creates ongoing story as Smith continues fighting for full release. The jurisdictional question matters. Smith is arguing Cannon didn't have jurisdiction to issue the injunction, that the case before her doesn't give her authority over the special counsel's report, that she's trying to exercise power beyond what her role permits. And if the 11th Circuit agrees, if they say Cannon exceeded her jurisdiction, that's a significant rebuke. That's a higher court saying a lower court judge overstepped. And that rebuke has implications beyond just this case. Affects Cannon's credibility, affects how seriously other courts take her rulings, affects whether she continues to preside over Trump-related cases. So the jurisdictional argument isn't just about this report, it's about checking a judge who's been criticized for pro-Trump bias. The presidential immunity question is lurking in the background because part of Trump's argument is that presidents should be protected from this kind of investigation and public exposure, that it's unfair to subject a former president to this level of scrutiny, that the office of the presidency deserves special deference. But Smith is implicitly arguing those claims are wrong, that presidents aren't above the law, that presidential conduct can and should be investigated and disclosed, that transparency applies to presidents just like to everyone else, and that argument, that rejection of special presidential immunity from transparency, that's important for establishing precedent, for saying that future presidents can't expect to hide misconduct behind claims of presidential privilege. The report's content is what makes this fight so intense. Because based on leaks and previous filings, we know Smith found extensive evidence of Trump's attempts to overturn the election, evidence of the fake elector scheme, evidence of pressure on state officials, evidence of the January 6th planning and Trump's conduct that day. And Smith apparently has witness testimony, has documents, has communications that show Trump's knowledge and intent, that prove Trump knew he lost but tried to stay in power anyway. And that evidence, if released, fundamentally undermines Trump's narrative, undermines his claims that he genuinely believed the election was stolen, shows he was lying, shows his attempts to overturn results were knowing violations of law, and Trump can't let that evidence become public without massive political and legal consequences. Smith's resignation complicates the picture. Smith has officially left the Justice Department, has resigned his position. But before leaving, he filed this motion, made this final push to get the report released. And that shows Smith's commitment, shows he wasn't going to leave without fighting for transparency, without trying to ensure his work becomes public. And his departure means someone else will have to carry the fight forward, will have to continue arguing for release, and that creates uncertainty, creates questions about whether DOJ will continue supporting Smith's position, whether they'll keep fighting for release or will back down. And Trump's team is probably hoping DOJ abandons the fight, hoping that without Smith's personal investment, the government loses interest. But so far, that's not happening. DOJ is still supporting release, still backing Smith's arguments. The appeals court's handling of this is going to be telling: how quickly they rule, what reasoning they use, whether they side with Smith or Trump. All of that sends signals about how seriously they take transparency concerns, about whether they think Trump deserves special protection, about whether judicial independence means protecting presidential conduct from scrutiny or exposing it. And whatever the 11th Circuit decides, it will likely be appealed again, either to the full 11th Circuit sitting en banc or to the Supreme Court. So this fight is far from over. It's going to continue through multiple levels of appeals and could take months to fully resolve. But each round, each decision, each legal argument, all of it keeps the issue alive, keeps people focused on what's in the report, keeps reminding Americans that Trump is fighting to keep evidence of his conduct hidden. So let's break down what Jack Smith's emergency motion means, why it has Trump's legal team stunned and scrambling, what the implications are for transparency, for accountability, for Trump's political and legal future. Because this isn't just about one report. This is about whether the American people get to see evidence of presidential misconduct, whether transparency wins over political power, whether the justice system can function when powerful people want evidence suppressed. First, the immediate legal battle. Smith is fighting to get his report released. Trump is fighting to keep it hidden, and courts are going to decide. And that decision matters enormously, because if the report is released, millions of Americans will read it, will see Smith's evidence, will understand what Trump did. And that knowledge affects public opinion, affects political support, affects whether Trump can maintain his narrative that he's been unfairly persecuted. So the stakes of this legal battle are massive, are about controlling information, controlling narrative, controlling whether truth reaches the public. Second, what release would reveal? Based on Smith's previous work, we know the report contains extensive documentation of Trump's attempts to overturn the 2020 election, details about the fake electors scheme, evidence of pressure campaigns on state officials, information about January 6th planning and Trump's conduct, and all of that documented with witness testimony and physical evidence, not speculation, not partisan attacks, but actual evidence gathered through legitimate investigation. And releasing that evidence changes the conversation, makes it impossible for Trump to claim there's no proof, makes it harder for Republicans to defend him, makes voters see clearly what Trump did, and that clarity is what Trump fears, is what he's fighting so hard to prevent. Third, Judge Cannon's role. She's the Trump-appointed judge who issued the injunction blocking release, and Smith is essentially saying she was wrong, that she exceeded her authority, that her reasoning doesn't hold up. And if the 11th Circuit agrees, if they reverse Cannon, that's a significant rebuke. That's a higher court saying a Trump-appointed judge improperly favored Trump, and that rebuke matters, affects Cannon's reputation, affects whether she continues to get Trump-related cases, affects how other judges view her. It might make her more cautious in future Trump cases, might make her less willing to issue rulings that seem overtly favorable to Trump. So Smith's challenge isn't just about this report. It's about checking a judge who appears to be letting political loyalty influence legal decisions. Fourth, the transparency principle. Smith is arguing that transparency is fundamental, that the American people have a right to know what their government does, what their president did, and that principle is crucial for democracy, for accountability, for informed voting. Because if evidence of presidential misconduct can be suppressed, if powerful people can keep their crimes hidden, then democracy doesn't work. Then voters make decisions based on incomplete information. Then accountability becomes impossible. So Smith fighting for release, that's Smith fighting for a core democratic principle, and that fight matters regardless of political affiliation, matters for anyone who believes democracy requires transparency. Fifth, Trump's defensive position. Trump is trying to suppress evidence, is arguing that releasing truthful information about his conduct would be unfair, is claiming he'd be prejudiced if Americans knew what he did, and that position is inherently weak because it amounts to arguing that transparency is bad, that the public shouldn't know the truth, that hiding evidence is necessary to protect Trump's interests, and courts don't usually accept those arguments, usually say transparency trumps desire to hide embarrassing or damaging information, So Trump is fighting from a weak position, is making arguments that generally lose, and that weakness is why his team is scrambling, is why they're filing emergency motions and desperate briefs, because they know the law isn't on their side. 6. The political implications. If Smith's report is released, Democrats will use it extensively, will cite it in campaign ads, will point to it as evidence of Trump's unfitness, will use it to justify their opposition to Trump and to Republicans who defend him, and that political use creates electoral consequences, affects swing voters who might not have understood Trump's conduct clearly, affects Republicans who might be wavering on whether to continue supporting Trump, affects down-ballot races where candidates have to explain their relationship to Trump. So the report's release isn't just about Trump, it affects the entire Republican Party, affects every Republican's electoral prospects, and that's why some Republicans might quietly hope the report stays hidden, might not want their voters to see clear evidence of what Trump did. 7. The precedent for future presidents. If Trump succeeds in suppressing Smith's report, that sets precedent. Says future presidents can block special counsel findings, can prevent evidence of their misconduct from becoming public, can use friendly judges to suppress transparency, and that precedent would be terrible for accountability, would encourage future presidential misconduct, would make it harder to investigate and expose corruption. So stopping Trump's suppression effort matters beyond this case, matters for establishing that special counsel reports must be released, that presidents can't hide evidence of crimes, that transparency is non-negotiable, and establishing that precedent protects future accountability efforts. 8. Smith's legacy. This fight is Smith's final major action. His last effort to ensure his years of work weren't wasted, his attempt to make sure the evidence he gathered reaches the public, and he's doing it even after resigning, even without official position. By filing this motion before leaving and ensuring the legal arguments are in place for others to continue, and that dedication, that commitment to transparency, even after his job is done, that says something about Smith's character, about his belief in the importance of his work, about his determination to serve the public interest even when it's difficult. And that dedication is admirable, is exactly what we should want from prosecutors, from public servants, from people entrusted with investigating powerful figures. 9th, what happens if Smith loses? If courts ultimately side with Trump, if the report remains suppressed, that's a victory for secrecy, for power over transparency, for the principle that presidents can hide evidence of misconduct, and that victory would be devastating for accountability, would encourage future cover-ups, would make voters more cynical about whether truth matters, would damage democratic institutions. So the stakes of this fight couldn't be higher, couldn't matter more for American democracy. And everyone who cares about transparency and accountability should be paying attention, should be following this case, should be demanding that courts side with release. 10th, the bottom line. Jack Smith's emergency motion is a final fight for transparency, a last effort to ensure evidence of Trump's election subversion reaches the public. And Trump's team is scrambling to stop it, is filing emergency briefs, is using friendly judges, is making every argument they can think of to keep the report hidden, and courts are going to decide, are going to choose between transparency and secrecy, between public's right to know and Trump's desire to hide. And that choice will echo through American history, will define whether this era was one where accountability survived or where power triumphed over truth. We're watching that choice be made in real time, watching Smith fight for release, watching Trump fight for suppression, watching courts weigh the arguments, and the outcome matters. Matters for Trump, matters for transparency, matters for democracy, matters for whether the American people get to know what their president did. And that knowledge, that truth, that's worth fighting for. That's what Smith is fighting for. And regardless of the outcome, that fight matters. That effort to ensure transparency matters. That refusal to let powerful people hide their misconduct matters. We'll keep covering every development, every filing, every court decision, every moment of this battle between transparency and secrecy, because this is one of the most important fights of our time. Whether evidence of presidential crimes remains hidden or becomes public, whether courts protect transparency or defer to power, whether American democracy can handle truth about its leaders, the answers to those questions are being decided right now, and they'll shape our democracy for decades. Stay tuned.